Okay, let's get started. Once again, welcome and thanks for joining today's session, What Anxious Heirs Call, a new tool for probate professionals, a webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. The presenters will address your questions after the presentation. If your question is case specific and confidential, please indicate that in the chat and someone will respond separately after the presentation. Our presenters today are professionals with extensive experience in all aspects of providing cash advances to individuals awaiting inheritance payoffs. Mark Harris has been working in specialty finance industry for 25 years, involved in purchasing over $100 million of assets. Most of his purchases pursuant to various state laws require court hearings, many of which Mark has either attended or appeared as counsel. As a result, Mark has the advantage of meeting customers, their lawyers, and establishing relationships to find collaborative solutions for the customer. Mark has spoken at numerous conferences, including the National Association of Insurance Commissioner, the National Council of Insurance Legislators, and the Pennsylvania Bar Institute. Born and raised in Tallahassee, Florida, Mark earned his undergraduate degree from Florida State University and law degree from Nova Southeastern University in Fort Lauderdale. Mark is married and has 2 children. Today, he's here to speak about the relatively new business of purchasing interest in actively pending inheritance claims.
Thanks, Molly. Good afternoon, everyone. Apologies in advance for the infomercial format, but hopefully this will be more informative than a corny commercial. Let's now be clear what this is not. We're not talking about interest in life insurance on or property owned by someone still living. Thus, we're not talking about buying senior settlements or remainder interest in real property. Those are different businesses, not what we're discussing today. This is not a loan. There's no fixed due date, no interim payments of principal or interest due, no stated rate of interest, fixed or variable, and no personal liability on the part of the recipient if the estate turns out to be insolvent or if the proceeds distributed to the heir come up short of what was originally anticipated. The only situation we're going to have a claim against a recipient is where the estate pays out, the recipient gets a hold of their inheritance, and then just doesn't pay us. That's just stealing. Or if someone flat out lied in the first instance about who they were and the relationship to the estate, that's fraud, and we'll try to get our money back. But if property sales are disappointing, or the amount of outstanding debt eats up the proceeds, or it all ends up taking years before a distribution, that's our risk.
Mark, you've been working in specialty finance for quite some time. What did you think when you first heard of inheritance funding?
Well, I've been in businesses for about 25 years that focus on providing upfront money to people who are waiting for future cash flows. Therefore, I thought this business made total sense. Probate is not as predictable as one might think, nor does the layperson understand the probate process and how much time it takes to finally obtain their inheritance. No, the average person believes that shortly after a death, there's a reading of the will by some lawyer, and the beneficiaries then leave the lawyer's office with their inheritance. At least that's the way it's usually portrayed on TV.
We know there are mostly lawyers from around the country on this call. Many of you have been wondering if beneficiaries taking an advance against their inheritance has any benefit to you as the estate attorney, or is this just another hassle?
Much of our business is referred to us by probate lawyers, also realtors and other professionals. In fact, many lawyers are grateful that we offer this service and they didn't know about us. Here's why. First, lawyers and trustees are regularly being called by anxious heirs. These heirs don't understand the probate process, nor why it takes so long. Frankly, of course, they're only interested in receiving money now, and they want immediate answers in their inheritance. Most of the folks on this call, I imagine, have experienced firsthand the repeated phone calls, emails, and sometimes unpleasant and disrupting communications from beneficiaries. ProbateCash eliminates or at least curtails this disruptive communications to your office by providing those anxious heirs money today and waiting to be repaid only when the assets are ready to be distributed. Referring heirs to ProbateCash relieves financial pressure on beneficiaries that cause them to frequently call your office about why they still don't have their inheritance. Finally, we know that estate assets are often comprised of real estate. We're seeing that where homes sold immediately after being listed by the personal representative just months ago, those same houses are no longer selling in this interest rate environment. The delay to sell the homes causes an inherent obstacle for beneficiaries to receive their inheritance. We can help.
Does the estate have to have cash or other liquid assets?
Real estate, in many instances, real property is the significant asset of the estate. In fact, it's this illiquidity that causes heirs to pursue in advance to prepare for the sale of the property and to wait for that sale to close. Heirs often need access to funds, but there are limited estate resources from which a preliminary distribution can be done. If you practice in a state where the property is homesteaded, we can still work with providing advances to beneficiaries there too. Ultimately, can we provide with the cash estate? Yeah, of course. Is an estate required to have cash assets? Absolutely not.
If an heir or a client called you and asked you about getting an advance on their inheritance, what would you say to them?
Well, wearing that attorney hat, I guess it would depend on whether the question came from my client, in this context, usually the executor, the estate, or from an heir who is not my client, but still kind of a constituent. In either case, I might offer the standard qualifications about not substituting my business judgment for theirs. If it was my client, I might briefly explain the process, note that this kind of advance can come with a significant cost at the end, and ask if they had any other source of cash to meet their immediate need. If they still wanted to proceed, I may tell them to take the amount of money that they really must have and not too much more. If the question came from an heir, not my client, I'd tell them that I would need the executor's permission before disclosing any confidential estate details with a third party. If they were intent upon proceeding, I might tell them the same. Don't take more of an advance than you need to address their identified need.
Are there any laws that govern inheritance advances?
And you being a little familiar with the business or ahead of that, so you know that California is the only state in the country that has a statute pertaining to assigning an inheritance. And that's, if anyone's here from California, it's California Probate Code 11604. No states prohibit these assignments. So what we do is we follow the spirit of California's code in each state, complete with filing the assignment with the probate court and all consumer safeguards incorporated in California's code. So if you have an estate and you're in Florida or New York, wherever it may be, that's not California, we're still following basically code 11604, the probate court code in California. It's got all the consumer safeguards, and makes the assignment very transparent and clear to all the parties.
Providing cooperation can take time. Will ProbateCash reimburse the estate for my time?
Yes, I know as well as anyone that lawyers pretty much sell their time. We'll reimburse you up to 1 hour for your time when you're helping out with questions that we may have or learn more information about the estate.
That says, probably on a lot of people's mind, what are the fees associated with ProbateCash?
Yeah, we should have probably covered that in our presentation. So that's a good question, of course, the fees. We charge as low as 15%. Our fees usually increase per quarter that the money is outstanding, and we cap the fees outside of a year. So if the money's out for 2-3 years, the fees have stopped accruing. The fees also, these are non-recourse advances. And so the more that we know about the estate, more comfortable we feel that there are assets there and there's mechanisms for us to get repaid, especially in states outside of California that don't have the statute, that we are more willing to negotiate those fees.
And again, if you come up with any more questions, or if you think about something later, which always happens to me, actually, you could always send up a follow-up email to Mark. So I want to make sure that you get their contact information. We can call Mark at 561-476-0018 or email him at mark, but that's MARC @probatecash.com. And so I want to make sure, we have another question that came in. So let me, what is the cost, for example, as a percentage? I'm not sure if that's too specific, but maybe.
So as a percentage, I think I'm saying that what is the cost, for example, as a percentage? So as an example, if there were a $10,000 advance, and by the way, we'll do as small an advance as $3,000. We've done advances north of $250,000. So usually we're all over the map as far as advance costs. Nothing really too small and nothing really too big for us to do. So let's say using the 15% point, and there is an advance for $10,000. If it's paid back within the first 3 months, that would be $10,000 principal plus a $1,500 fee. If it went to the next period, it would go up to 30% of the amount. So a $3,000 fee would be due, and so forth, capped to even.
Oh, perfect. Also, though, we will be sending you guys all another, every time we have another good question. Any involvement in a will contest to where the heir would get 0 if the will wasn't knitted?
Yeah, so that's a good question too. So it goes to why would attorneys want to refer cases to us? And that answer is also yes. And we've gotten more involved in because we keep seeing adversarial situations where someone's challenging the will and they need money to get by through the litigation, even to occasionally help with the litigation. We do review the case. We want to talk with you about where the status of the case. We do look at the arguments, the size of the estate, size of the advance. But we have been involved in adversarial situations where if a will was omitted, not admitted, someone's challenging whether the will. So a lot of the adversarial situations that you folks have seen can think of involving a probate.
Okay, I want to make sure we get all the questions. It looks like now we also will be sending out a follow-up email with a brochure with more information from ProbateCash after, and a link to this webinar, because there's so much great information covered and thrown at you. And I'm going to give everybody Mark's contact information one more time in case you have any more follow-up questions, or to keep this discussion, you can call Mark at 561-476-0018 or email him at mark, and that's MARC, @probatecash.com. Thank you again so much for joining us, and have a great day.